Versus Leahy.
Ms. Greenberg?
Thank you, Judge. I appear on behalf of Mr. Leahy. With the court's permission, I'd like you to direct you first to the Michigan versus Mosley problem, and I think what I'm asking you to do is send me to Washington. Mosley does set out a clear four-prong requirement. The one that concerns us here is that Mosley appears to say that a defendant cannot be re-questioned about the same crime once he says he doesn't want to talk.
But that's not what he said. I don't want to talk right now. Give me a minute. That is just different. He's not asserted his Fifth Amendment privilege not to talk here. He's just said, let me get my thoughts together. Give me a minute, or I'll be ready in a minute. How is that an assertion of the Fifth Amendment privilege?
Well, we are here bound by the findings of the trial court, and the trial court does say, and I direct you to page 18 of the defendant's record appendix, which is page 5 of the trial court's decision and ruling. Cook's, that's the interrogator, attempted to elicit information from the defendant, but the defendant did not want to speak. And we do have a defendant here. The Commonwealth makes much that he was repeatedly Mirandized.
Well, actually, the judge goes on to say, when he was asked if he wished to speak, the defendant said, not now. I need to figure things out. In a minute. The officer respected this request and waited 20 minutes before asking again. And the defendant responded, I'm ready to talk. So we've got to look at all of his findings, not just one sentence here, I think.
Well, we look at his findings. We look at his conclusion. The defendant did not want to speak. And we also bear in mind that the interaction between the defendant and the state police was not recorded. It may be one of the few conversations in the Commonwealth not recorded. The defendant did not have, of course, the benefit at trial of your ruling, which says that an unrecorded admission is to be treated with some suspicion, but of course this court does. This is the interaction that the court reports, and the legal question is of interest and does need to be answered. May a defendant, assuming he has properly asserted his right to silence, which the trial court found he did, may he then be re-questioned on the same topic? The law is not clear on this. There's some split among the federal courts, and we have not decided this issue under Article 12. Obviously, we can't give less protection than the federal courts do. We might give more. Article 12 does provide more. May they go back and say, it would be helpful to you to talk about the murder, assuming a person says, I don't want to.
Right now.
Right now. And that would be the question before you, and I hope to have your opinion on it, because it would be useful, I think, in a situation like this for the police to have a bright line guide as to what's appropriate. We do say, and the question would be, is this case like Miranda warnings? We say, you know, what do the police have to do here? The three things they have to say. If they don't say them, it's not voluntary. And then we have in Mosley, here are the four things the police have to do. If they don't do it, it's not scrupulously honored. So the question would be, is scrupulously honored kind of a wavy thing where the police make it up and the judges have discretion, or is scrupulously honored 1, 2, 3, 4 as set out in Mosley? That is Mosley like Miranda and setting a bright light rule, or is it a wavy discretionary thing? And we don't have any law on that question in this state, and it would appear that the federal law is at this time unclear and somewhat split. So I think it would be helpful for the court to rule on this question. I have other issues here I'd like the court to look at. I'd like the court to look at the problem addressed. I mean, I'm very sympathetic to the trial judge in this case. He did a whole long trial. Then he did 50 pages of instructions, which were perfect. That never happens, 50 perfect pages of instructions. Unfortunately, during the 50 pages of instructions, it appears that one of the jurors just kind of slept through it, I guess. He comes back with the question, could I have that again? There isn't a tape recording that they play them from the record. There isn't any written instructions. Apparently, one juror, it would appear, missed the whole thing. Said, could I have it again? It goes back to the court, says, could I hear it again? And the judge apparently risks reversal by saying, no, you can't. And then they go back. This is not a very sophisticated jury for reasons we'll discuss later. 10 of them never read the papers. If you look at the questions, and that's why I photocopied them into the brief and into the record appendix, this jury as a group doesn't understand what's an element, what's a plea, as opposed to they don't understand anything. If you look at the questions, I mean, we give great respect to the capacity of juries to determine truth from deceit and to weigh evidence, but this is a jury uncommonly not literate.
Let me ask you this. Is it your position that whenever a juror asks for the jury instructions to be given again, that a judge must do that?
The judge is obliged under the Due Process Clause and for the constitutional authorities cited in my brief, state and federal, to clarify the jury's confusion. A judge.
So whenever a juror says, I'd like to hear it again, I didn't follow it, then your position is the judge must give the full instructions again?
Let me give you a staggered answer. The judge should give the whole thing again. If the judge can't stand to give the whole thing again, possibly the judge could say, what part didn't you understand? That is, the judge has a duty to attempt to clarify. Then the juror could say, I was sleeping through the whole thing. I couldn't hear anything from the left. I didn't understand your long words. Or I didn't get what you said about reasonable doubt during that portion. I sneezed. That is, the judge's duty is to clarify juror confusion. It's not enough for the judge to say, I instructed rightly on the wall, but one juror was having a seizure during it. The judge has to clarify the jury's confusion.
So if a juror sat there and was daydreaming, juror had a bad day as they left and had an argument with a spouse, and they couldn't concentrate, it wouldn't matter. Under your theory, if a juror says, I missed it, Judge, would you do that again? You would say the judge is required to do that.
Absolutely. You got a person on trial here with the possibility of life without parole. If there's a juror that's dreaming through the instructions, then you're going to get him convicted by a jury of 11, and that's not constitutional.
That juror has the opportunity to collectively, the jury acts as a collective body. And surely other jurors, I mean, that's what they do with witnesses. Well, one juror might say, I don't really remember what that witness said. And, well, I remember he said this. I remember he said that. That's a way the jury works.
I was so hoping you would ask me that.
Well, I'm pleased I did then.
I was so hoping. Here's why that's different. Because juries are charged with collective recollection of the fact. They combine together and they say to each other, what did you hear, what did you see? But the jurors don't take the law from each other. Jurors don't instruct each other on the law. Judges instruct the jurors on the law, and the instruction on the law.
But the judge has instructed, and some jurors obviously have, and this will always be the case, some jurors have heard words differently than other jurors. This is a natural process. What did the judge tell us about that? I thought he said this, I thought he said that. No, you're right, he said that. That's a natural process. Now, if they're out of that, there arises a specific concern because there's a conflict between jurors as to what they remember the judge instructing on a specific point. Then, of course, if they can't resolve that, they can go back to the judge, which they do here.
But that's what they do.
Later on, they do here. They say, we need, further advice or further guidance on this issue. But just, would you do it again for us, Judge? Somebody missed it, or somebody would like to hear it again because then it would be clearer. That doesn't seem to me a requirement that the judge then go out and do the whole thing over again.
It's a shame it doesn't seem it to you. It would appear, if what you're saying is right, then if one juror went to the bathroom during jury instructions, then the other jurors could just fill him in.
Ms. Greenberg, I don't think that is a fair inference from what Justice Cordy has said. And let me suggest this. This is unusual because we actually have it in writing, which is to say, sometimes when we read a transcript, we can't get the full inflection.
Yes.
As I understand it, a juror wrote a note that says, instruction of definition of armed law, and that was crossed out, and then request for all instructions by judge. What the judge wrote back was, the court will not re-instruct you at this time. Am I correct?
That's correct.
If the juror had found that he or she, I can't tell if it's a he or she from this, was not able to understand something, it's not clear to me that it's something other than armed robbery. It does say request for all instructions by judge. It seems to me the judge is proceeding as judges often do, step by step by step. We don't have a case where the judge, there's a second request to re-instruct at this time. And as far as we know, the jurors proceeded. There's nothing from this record that I can see that the juror was asleep. I take it if the juror showed that he or she was asleep, defense counsel would have drawn that to the attention of the judge at the time. I don't assume that this juror is illiterate. It is not clear to me that only people who are literate are able to follow instructions of a judge. And I, frankly, have a difficult time in thinking that when one gets a request like this, there's an absolute constitutional obligation to automatically re-instruct on everything.
It would appear that the 3 notes given to the judge are written by the foreperson. They're duplicated in my record appendix at pages 80 through 81,
Right.
as well as in the body of the text. I am not suggesting that only literate jurors may serve, nor am I suggesting that a juror was physically asleep. It appears that a court officer told the judge, and it's the page number is actually in the Commonwealth's brief, that it was one juror who was confused by the instructions as a whole, who that was the genesis of the request for all of the instructions again. It would appear from the 2 other questions returned to the jury, which also are crossed out, that the jury as a whole does have some confusion as to the law. It does appear that it's a theoretical question whether jurors may simply take the law from one another and reach a consensus as to what law governs, or if,
I'm not sure that that's
Yeah.
the correct.
as Judge Cordy suggested,
Well, what the
No, what
judge-
Judge Cordy may have been suggesting is the jurors will discuss what their memory is, not what
Of
the
the
law
instruction.
is. But do we have, in deliberate premeditation, do we have to go through the 3 prongs of malice? I thought that's what the judge said. No, he didn't, or no, she didn't, because, oh, yes, I remember. That's not taking instructions from one another.
well, if a juror were not able to remember what the law was that the judge gave, would not the proper procedure would be for the juror to ask the judge what the law was? Because that would be the only way we could be confident that the juror was instructed properly and knew what the law was. If the juror were to take another juror's recollection in secret, we would have no way of knowing. When a jury, had the judge answered this juror question with the answer, juror number 10, if you don't remember my instructions, please ask juror 9 what he remembers, this court would be constrained to reverse. We don't have the judge saying, just ask juror number 9 if you don't understand it. But and that would be the question here. Are jurors to take their memory of the law from one another when they express confusion, or are they to take the law from the court upon inquiry? And does the court have a constitutional obligation when faced with juror confusion, even if it's the confusion of one juror? Does a court, when the court sees that a juror is confused,
how do we know
have a
the
duty
jurors?
to respond?
How do we know there's juror confusion here? We'd like to hear it again. Doesn't necessarily mean confusion on any particular point. Most jurors would love to hear it again, just because it's long and it's somewhat complicated. How does that translate into specific juror confusion on a point of law? We'd like to hear it again. I mean, I'm just trying to figure out how that translates. That's very different than we do not understand. Would you re-instruct us on the element of premeditation? Or would you tell us how premeditation, would you refresh our recollections how premeditation applies to this thing, which is a specific, concrete item that they're unable to agree on?
You know, I would leave it to the court. I can myself imagine no other reason a juror would like to hear it again unless they didn't understand it the first time. It seems unlikely they would like to hear it. It's not rock solid.
They'd like to understand it better. They'd like to hear it again,
Yes.
see if they understood it correctly the first time.
Yes, they would like to understand it better. That seems to me if the jury would like to understand it better before ruling, then the judge has an obligation to allow the jury to understand and not to ask each other, what do you think that meant, but to ask the court.
Not what do you
to
think that
clarify.
meant, but how did the judge instruct us?
Yes, what did he say?
What did he say? That's
what
correct.
did he say? They want to know what he said.
Who wants to know what he said?
One juror.
One
and
juror
me.
wants to have a re-instruction.
Right.
All right.
So
And the judge
otherwise
said,
we
not at
don't
this
know
time.
it.
That was right away, not at this time.
Not at this time.
Not at
But
this time.
I think you have my argument. I'll direct myself to the first issue, which is presented here, and that is whether, and I do want to address myself to the preservation issues here, too. We have a very widely publicized crime. I have asked the court below to transfer the 70-some articles which were submitted, and I don't know if you have them. They won't let me bring them by hand, but I will pursue it.
Well, we
If-
have, under 33E, we look at everything.
Yeah, so you have 70 articles, and each one of them, defendant Paul Leahy is described as sexual recidivist, Paul Leahy, repeat sexual offender, Paul Leahy. The Commonwealth itself concedes there is no article where it says Paul Leahy, as trial counsel argued below. You would think repeat sexual offender was his last name. That's what the articles say. And it's a murder where the publicity gave details which would shock the conscience. There is no question here. So what the trial, but it wasn't so huge as to taint the whole pool, and the defendant never argued, and he didn't have to. We got to move out of Plymouth County. What he said was, let's find people who haven't heard of it. I think we can do it here. I want to be in my own venue, and I want 18 peremptory challenges, and I want everybody off who's heard of the case before.
And that's simply not our rule.
Pardon me?
We don't exclude people just because they've heard about a case.
Right. Well,
That's not our rule.
The question would be what they heard, and that's
And whether
why.
they are capable of setting it aside and being impartial.
Absolutely.
Right.
And the question is, right, I don't disagree with you. Nevertheless, we have Irvin versus Dowd, and we do have people. The question is, could they have heard of it and not heard things which it was impermissible for them to hear?
Well, you made the point earlier that 10 of the jurors never read the newspapers.
Absolutely. So it would have been possible to get 12.
Well, are you suggesting that the jurors who didn't read newspapers didn't receive information from television?
Well, they said so. There was inquiry made.
So you're talking about those 10 didn't read the newspapers or watch television?
They had not heard of the case.
Okay, fine.
But two had. I think two had. And the question is, was it correct to ask the defendant to exhaust his peremptory challenges to get rid of people who had heard of it, but who said they could be impartial? You have before you a complete duplication of the inquiries. There's some he has to wipe out a peremptory
Did he challenge those other two people for cause?
He challenged, it was kind of all ruled on in limine. He's challenged before, he challenged during, and he said after. He doesn't want for cause anybody on the jury who's heard of it before. And then after all the jurors are selected.
But as Justice Cordy said, though, that isn't our rule. Did he challenge Juror 12-5 for cause?
He challenged at the end, he challenged as they went through, and then after all the jurors were set, I mean, the trial judge...
So he made a specific challenge to Juror 12-5 for cause?
He said at the end he wanted everybody off the jury who had ever heard of the crime. He said it
So he did
before.
not challenge Juror 12-5 for cause, then?
He didn't specifically say 12-5. He challenged those remaining in the pool who had said they had heard of it. That would be two of them. And he did say before, I don't want anybody on it who's heard of it. And he said 6 times during, I don't want anybody who's heard of it. And he said at the end, I need you to strike for cause anybody who's heard of it. So he did as much as could be done, and the trial judge was clear throughout he wasn't going to strike those people. So it would have been at that point.
So what in the record
Futile.
indicates that the judge should have removed Juror 12-5 for cause?
The judge, I want to argue the juror should not only have removed 12-5.
No, but my question is,
Your question.
what in the record would require the judge to remove Juror 12-5 for cause?
Because she doesn't say I can be fair.
She said it, in a sense, earlier.
Well, the law is that a general answer to general questions, and if you look at my reply brief, you'll see the federal authority, therefore, that the general answer to general questions at the beginning is not good enough, and you'll see also that those answers, I think so and I might hope so, the law is clear, and I cite to the Gonzalez case that, I think so and I hope so are not good enough. But in addition to Juror 12-5, we have a different problem. We have what happened to the guy's peremptory challenges. Because not only, it's not...
Well, he had them. When Juror 12-5 was impaneled, he had peremptory challenges. He didn't use a peremptory challenge on 12-5, did he?
But he had to use them on all the other ones.
Well, later on he used more, but when 12-5, I mean, if he'd run out of peremptory challenges at 12-5, I assume he could have asked for more then.
I want to say the law does, it would be an additional, the question is not 12-5. The question is, do I get 16 without having to bump them on people who say, this crime was horrible and that's my firm opinion before I'm going in. Let's talk about that.
But you're complaining about Juror 12-5, and he had a peremptory challenge that he could have used to remove 12-5.
I'm not making myself clear, I'm afraid. The defendant has two arguments. One would be that even in the absence of a showing of prejudice, the requirement of exhausting his peremptories on all those people he had to waste them on makes this trial unfair. He had a constitutional and rule-based right to 16 peremptories, just like anybody else. And he had to toss them all away on people who saw in the paper and walked in saying, "This, I already know this was cruel and
Ms.
atrocious."
Greenberg, you can see your red light is flashing.
I thank you.
No, you can
Yeah.
can say the second
Thank
argument
you.
in a sentence.
Thank you. So that would be the first. He had to waste the peremptories on people that should have been excused for cause. No prejudice needs to be shown. The second argument is if you do have to show prejudice, Juror 12-5 is it, and you don't have to, there's no requirement that he had to use a peremptory on this one to say, or it would be a completely new requirement. In order to preserve that issue, all he had to do was exhaust them altogether, because once the judge said, I'm going to force you to use peremptories on these, he had to save them up. He didn't have to use them as he went on everyone. He had to preserve the error, but he still had to try and win. That would be the argument. Thank you.
Thank you, Ms. Greenberg. Mr. Thompson?
Good morning, Your Honor. It's Robert Thompson on behalf of the Commonwealth. Your Honor, I'll address the issues raised by the defendant in the order that she took them. Your Honor, for there to be an assertion of right to silence, it has to be clear and unequivocal. And cite this Court's recent opinion of Commonwealth v. El Monte that was issued in June of this year saying that. That's at 449 Mass 511. Here, there was never a clear and unequivocal assertion of the right to silence. What he said was he wasn't going to talk right then. He needed a minute. He wanted some time to think about it. He wanted time to think about whether he was going to assert the right to silence. He was not, in fact, asserting the right to silence. He asked for a minute. He was given 20 minutes. Your Honor, the judge below did not find that there was an assertion of the right to silence at that point. He was not asked to make that finding. Michigan v. Mosley was not argued to him. What was argued to him was in the general totality of circumstances, the statement was not voluntary. There was no assertion in the argument presented to the judge that this was a violation of Miranda under Michigan v. Mosley. The findings by the judge, the detailed findings, have him saying just what I said. Not right now. Give me a minute. I need to think about what I'm doing. There's no assertion of the right to silence. There's no need to consider then whether or not any assertion of the right to silence was scrupulously honored. Your Honor, if there's no further questions on that, I'll move on to one of the other issues, Your Honor.
That's fine, Mr. Thompson.
In terms of the question from the jury, I submit that it was within the judge's discretion to consider the question premature after 20 minutes into deliberations, after the 50-page charge.
Mr. Thompson, may I ask you this, and forgive me if it's in your brief and I've overlooked it, or in Ms. Greenberg's brief. When the judge received the inquiry from the jury, was there some discussion with counsel?
Yes, there was, Your Honor.
And what was the nature of that discussion?
The judge said that he was inclined not to repeat the instructions. The defense counsel then said, I would ask that they be re-instructed. And the Commonwealth then said, it's only been 20 minutes into deliberations. And then the judge said, I'm going to give my opinion about it.
Let me ask you this hypothetical. Let's say a judge gives a charge and there's a juror who has a hearing impediment. They don't hear all the words. They don't say anything until the judge completes it, and then they go into the jury room and the juror says to the foreman, I didn't hear everything, and so I'd like to hear it again. The foreman sends out a note that says that there's a juror who would like you to give the charge again. Must the judge give the charge?
Your Honor, no. I would say no, Your Honor. I suggest that one of the purposes of a 12-person jury is, as been suggested earlier, is for the jury then to have the ability to rely on their collective memory of what was said to them in the charge. That they can, indeed, not speculating on what might be meant by the law, but what indeed was said. And as long as the jurors collectively can arrive at an appropriate decision as to what was, for them, a confident decision as to what was said, then that would suffice, Your Honor.
I take it that implicit in that broad description, Mr. Thompson, and we can't guess as to what went on, a juror says, my memory is different from yours.
Mm-hmm.
They begin to discuss it, whatever aspect of whichever indictment they're discussing.
Mm-hmm.
And a juror says, that's not my memory, insists that that isn't his memory, not that he didn't hear it, but that wasn't his memory, and at some point is persuaded that, in fact, his memory is incorrect. The Commonwealth's view is that's fine because the other jurors are not instructing him on what the law is or her, but whether or not the other 11 people, or however many happen to be in the jury, have agreed that that's what the judge instructed. Correct? I mean, for your purposes, there's no difference between memory of what the fact was or memory of what the jury instructions are.
Yes, Your Honor. That is part of that's part of the purpose of having a 12-person jury, is to sort of assure that amongst the 12, they will be able to come to an agreement as to what was said to them in the instructions. If not, then they can come back and ask specific questions from the judge.
Was there any, in the colloquy as you've described it, I take it there was no discussion about this instruction of definition of armed RO?
No, Your Honor, there was none. Okay. Nothing reflected in the transcript. Your Honor, the premise of the defendant's position on this is that the question itself shows that the jurors did not understand the instructions that had already been given. Both this Court and the appellate court have rejected that concept, Your Honor, that merely asking a question is indicative of some kind of misunderstanding of the instructions, or some kind of confusion, or a basis for thinking that they somehow misapplied the law in arriving at a verdict.
Well, somehow a court officer had the impression that there was a juror who was confused.
Somehow the court officer had the impression that the question was initiated by a single juror. I don't know any more details on that, but somehow he did.
Does the record tell us any more the basis of the confusion?
No, Your Honor.
So it may be that the person heard the instructions, didn't understand them. It may be that they heard the instructions, but they were confused about parts of it. We don't know.
Confusion is a word that's not in the record, Your Honor. I mean, that's a word that we're adding into this. I mean, the question was initiated by a single juror, but we don't know at all that there was confusion, Your Honor. For all we know, this juror simply wanted to make his job easier by having the whole thing repeated to him, Your Honor.
All right.
Did the jury come back with any other questions?
Yes, they did, Your Honor.
So they didn't get the impression that the judge had rebuked them for asking
No, Your Honor, that's one of the points that I would have made here, Your Honor. The judge's response, I will not re-instruct at this time, left open the option that they could come back with any particular questions that they actually needed some real help on. And in fact, the jury must have understood it that way, because they did, in fact, come back.
They came back twice.
Twice, Your Honor.
And both on specific elements of specific indictments,
Yes, Your
as I
Honor.
recall.
Yes, Your Honor. Your Honor, from a couple of different perspectives, it just is not and never has been per se reversal for a court to accept a verdict when there have been questions for the jury that have not
Mr.
been
Thompson.
answered for one reason or another.
Forgive me for interrupting you. I think Ms. Greenberg is probably correct that it's remarkable that one has what is in a transcript 50 pages of jury instructions with not a single slip of the tongue or error. I mean, trial judges face an enormously complex challenge when they are instructing a jury. Do we know whether or not Judge Chin was using written instructions? Is there anything
I don't know that one way or another, Your Honor. I don't think there's anything in the record one way or another on that.
Was there any
Your Honor.
suggestion by defense counsel that the judge, give the jury a copy of his instructions?
I don't think that was brought up by anybody, Your Honor.
Okay.
Some judges do that. I don't think it's a bad idea. It has never been a requirement. and
No, I
don't believe
understand.
it's
It's just perhaps incorrectly, I assume that the trial judge was using, not unreasonably, written instructions that he had for himself, and it's when somebody asks for the entire body of instructions to be given again, one relatively easy way to deal with whatever the issue is to say, no, but I can give you a copy of my instructions.
I have no idea what form. I would presume as well that he's not winging it, that he does indeed have something in front of him. But whether it's in a form that's readily reproducible, I have no idea, Your Honor.
Okay.
There's a variety of cases Scott at 428 Mass 362, Harvey at 397 Mass 351, and Hakia from the appeals court at 42 Mass Appeals 129, where for one reason or another, answers to jury questions did not reach the jury before they were satisfied enough with what was going on to return a verdict, and that has been deemed to be fine because it's the jury that is in the best position to decide whether they actually need further instructions. Here, they knew they could return for further instructions, and they decided they didn't need anything more than those two later questions that they asked. Your Honor, viewing the instructions as a whole, which is our established law, there is no reason to think that the law was misapplied during the deliberations in this case here. In terms of the pretrial publicity, Your Honor, the focus of the trial counsel, defense counsel in this case, was on whether the jurors had any prior knowledge of the defendant's record or the idea that there were sexually dangerous persons proceedings against him. That was the focus of all his questions to the court, all his argument to the court about what was needed, and that was addressed and focused upon appropriately by the judge. Anybody who had any knowledge of that prior record was excused. Now, he did ask for that broad, generally for anybody who'd ever heard of the case at all be excused.
Mr. Thompson, forgive me again for interrupting you. The defendant, as Ms. Greenberg has said, did not request a change in venue, correct?
That's correct, Your Honor.
What was the basis of his asking? I mean, was there some – I mean, the law is very clear that jurors who are aware of the facts that might have led to an indictment are not automatically excluded from a jury.
Yes, Your Honor.
Was there some reason why did trial counsel give some explanation as to why the judge should apply a different kind of law in this case?
Because he was arguing that the vast majority of, if not all of, the vast majority of the publicity in this case reflected information about the defendant's prior criminal record.
But as I understand from you and from Ms. Greenberg, that what he asked for is anybody who's heard anything should automatically be excluded.
Because the idea is that the idea he presented to the judge was that anybody who was exposed to the media could not but be aware of the prior record. It was focused, is my point here, Your Honor.
I see. So the judge, by making inquiry, and if the juror didn't happen to mention.
No, yes, specifically, do you know anything about this individual's history? And they had to say no, Your Honor.
Okay.
They had to say no in order to get to the next question.
If they said they knew anything about it.
They didn't have to say, the judge didn't.
No, I don't mean that
they weren't instructed to say no.
No, they weren't instructed to say no. No, that's not what I meant at all. In order to be accepted as a juror, they had to give a definitive indication that they had no knowledge of the defendant's prior record.
Well, it wasn't asked quite that way.
Now, I'm not trying to quote him, Your Honor. It was asked a little more subtly because that would certainly expose the prior record.
Exactly.
I take it that one of the examples of which the defendant now complains is, what did you read in the paper? Basically, what happened at the Burger King. Do you recall any facts concerning the defendant? I can't recall. It's so long ago. Okay, how long? Well, when the case happened. You haven't heard anything recently. No, I'll ask you to remain. Is that a fairly typical way?
That's fairly typical, yes, Your Honor. Yes, Your Honor. It was focused on what do you know specifically about this individual, not so much the focus of the defense request or any of this was not so much on did you hear about anything concerning the way the murder was committed. That wasn't the focus. Now it's the focus of the defense counsel, but it wasn't then.
Or where it was committed.
Where, no, I mean, not the factual nature. It had to do with the defense background.
What was the defense in this case, by the way? It's not really apparent from the briefs.
Your Honor, frankly, there was very little possible defense in this case.
No, that wasn't the question.
No, Your Honor, the defense that was presented was that it was not planned, not premeditated, that it was essentially reactive to everything that's going on, attempting to get apparently a second degree rather than a first degree murder.
All right. Did the defendant call any witnesses, or was this simply cross-examination of the Commonwealth's witnesses?
Cross-examination, yeah.
An argument was...
Essentially on that it was not a
Second degree
planned
murder.
thing, it was not deliberate, it was all reactive, it was just,
It was second-degree murder. There wasn't evidence to meet a first-degree murder.
that's essentially what it was.
What was the defense counsel's bottom line in argument? Return a verdict of second-degree murder or acquit?
I'm sorry, Your Honor, I don't remember his final point. Your Honor, in terms of the seating of Juror 12.5, which is the only one that the counsel now raises specific objections, there was no individualized challenge for cause beyond that general challenge to everybody who had heard anything about the case. There was no request for further questions to that particular juror, though the judge had invited counsel to suggest further questions if it became appropriate during the individual voir dire. And in fact, whenever the counsel requested further questioning of a juror, the questioning was done. And at that point, when that juror was seated, the counsel had 15 peremptory challenges left. Your Honor, I suggest that in order to preserve a complaint, a complaint or excuse for cause, you must use an available challenge on the juror. Otherwise, by accepting the juror, you're really in no position to be able to later complain that this juror shouldn't have been on the jury when you have every opportunity to have them excused.
Mr. Thompson, I understand the theoretical underpinnings of your argument. The difficulty for trial counsel is as follows. Trial counsel has a limited number of peremptories. And if trial counsel knows that he or she is going to have to use a peremptory once he or she has lost the underlying argument, if you've heard about this, you must know something about the defendant. That places the defendant in a very difficult position.
It's a difficult choice, as many choices are difficult during a trial. The choice here is that if you truly believe that this person was so biased or prejudiced that they should have been excused for cause, if you truly think that that is such a weighty concern, then you need to use your peremptory challenge to do so.
Or you ask the judge to ask this particular juror, I assume, some additional questions.
Well, here, Your Honor, the only issue that's preserved is the general question, the general objection to every single juror who heard anything about the case. If he had particular problems with the way this particular juror responded to the questioning, he should have brought them up. Your Honor, in terms of the being denied the opportunity...
Mr. Thompson, could I ask you one other question?
Sure.
Again, we haven't read the entire transcript. What evidence came before the jury as to the prior history of this defendant?
None. None. He was working at the Burger King and the crime was committed.
Thank you.
So, and that is essentially why the defense counsel was so concerned about that particular information, because there was no expectation that that would come into trial, as opposed to the evidence that he fully expected, that the defendant there would be evidence that the defendant was found in the bathroom with the victim's wallet in his hand covered with blood.
Right.
Your Honor, in terms of being denied an opportunity to exercise a peremptory challenge, Your Honor, the last peremptory challenge was used as the last seat on the jury was being filled. The juror who, after the challenge was used, the juror who filled that, there was no indication that that juror had any prior knowledge of the case, was exposed to any publicity, was subject to the challenge for cause, or that there was any other reason that the defense might have wanted to use a peremptory challenge there. In that situation, the defendant has not been deprived of an opportunity, not shown he's been deprived of an opportunity to use a peremptory challenge he would have otherwise used, and that's an insufficient showing here. And, Your Honor, in the cases that support that proposition are cited in my brief.
Did the defendant ask for additional peremptories?
He asked prior to the impanelment for additional.
I mean, after the last juror.
No, Your Honor.
Thank
Your Honor, if there's nothing else, then.
Thank you, Mr. Thompson.
You.
Okay.